Hi, this is Brian David Hill. I am submitting this video exhibit and argument as to my actual innocence to my charge of indecent exposure under Virginia statute. This is January 5th, 2022, and this is the evidence I wish to present both the Martinsville Circuit Court, the Virginia Court of Appeals, and to the federal court, the U.S. District Court for the Middle District of North Carolina, for my 2255 motion. This is Brian David Hill. My address right now at this time is 310 Forest Street, Apartment 2, Martinsville, Virginia, 24112. And so, anyways, I declare under penalty of perjury that the foregoing is true and correct. Executed on January 5, 2022. This is the evidence I wish to present the courts in regards to my actual innocence for indecent exposure. This is one of the pieces of evidence I like to present. This is a return receipt of a mailing that was signed for by somebody at Martinsville Police Department. And it was for G.E. Cassidy. G.E. Cassidy. And it was mailed by Ken and Stella Fornash, 916 Chalmers Street, Apartment A, Martinsville, Virginia, 24112. That is my grandma and grandpa, and this is the proof. They had mailed letters regarding the body camera footage. They refused to comply with the court order. Martinsville General District Court and Martinsville Circuit Court both put in court orders in accordance with U.S. Supreme Court case law, Brady versus Maryland, regarding criminal case discovery materials. Martinsville Police Department had violated those court orders because they refused to turn over the discovery materials of the police body camera footage. I knew they had recorded it. I had told my counselor at the time, Preston Page, when I was arrested for indecent exposure, I told Preston Page that the police recorded me and turned on the button with the red light coming on in the body camera footage. I knew they were recording it. And the court had asked the prosecution for that evidence. They did not turn that over. They have violated 3 different court orders. One for reciprocal discovery, one asking for discovery, and the General District Court asking for discovery. So the prosecution had violated 3 different court orders violating my Brady rights. It is all illegal. Now, of course, the police ignored any evidence my grandparents may have mailed to the Martinsville Police Department. Now, I also like to present this, an envelope that was given to me by my attorney at the time, Matthew Scott Thomas Clark, the court-appointed lawyer in the Martinsville Circuit Court, who was a court-appointed lawyer for my case of indecent exposure. This is a copy of the fax that I had faxed to Martinsville Police Department right here. This is a copy of the fax. I have it. I have a copy of the fax. Why would I have a copy of stuff that I faxed to the police department and mailed to the police department? You're wondering, wait, the police got it. How did you get it, Brian? How did you get it? Oh, that doesn't make any sense. I have the envelope that was signed for by the police chief, G.E. Cassidy. He signed for it. The police chief of the city of Martinsville signed for it, and they received the fax. After that, G.E. Cassidy signed for the envelope, and then it's under restricted delivery. You see? G.E. Cassidy, turned over to the Commonwealth Attorney on 8-7-2019. You see all this? And the tracking number. The tracking number, and guess who it was sent? By Brian D. Hill, with my signature on it, my John Hancock. Now, this is the evidence that I like to present the court. First of all, it has never been opened. You see that? It has never been opened. It is sealed. You see the light glistening off the tape? It has never been opened. And there's where it says restricted delivery and the return receipt. What I like to present to the court is an envelope that I mailed to the police department on the date of July 19th, 2019. Let's see. A few months after I was released out on bond, federal bond, and then later time I was also put out on state bond. After I turned myself in to get the state bond conditions and the federal bond conditions. So anyways, after I went through all that, I had gotten together a lot of evidence. You see all the papers in the envelope. All of that evidence was mailed to Martinsville Police Department. Now, what exactly was I mailing to Martinsville Police Department? I had mailed evidence. The photocopies of the threatening greeting card and the other anonymous greeting cards, which is targeted harassment campaign at my mother, Roberta Hill. This proves that she was being harassed prior to the indecent exposure incident. And also, I had also presented overwhelming cumulative evidence that I was a victim of carbon monoxide poisoning before I was arrested for indecent exposure. This has also been proven in the hospital record as I had tachycardia. After I was arrested, I had 2 resting blood pulses of over 100, and any resting blood pulse that's over 100 BP, or no, that's blood pressure. Let me see. Anything that's over 100 in regards to resting blood pulse is tachycardia. And tachycardia means I was having some kind of heart issue or some kind of heart issue or health issue at the time I was arrested for indecent exposure. The hospital did not do anything to look into this, and yet the Martinsville police officer Robert Jones of MPD, he had lied under oath, and he said that Brian David Hill was medically and psychologically cleared. He lied that I was medically cleared. I was not medically cleared. They prematurely released me when I had tachycardia. They were going to do laboratory work, but the lab results were not completed because it said results were to be deleted from the chart. So that means they canceled the tests. And the police officer said normally they do laboratory tests. They did not. He did not know this. He lied. He admitted in federal court, in the transcript, September 12, 2019, he admitted in federal court under oath, I did not look at his laboratory results. I didn't look at his medical records. And he had the gall to say under oath I was medically cleared when he didn't know that for a fact. He didn't check the medical records. He didn't look through any of that. And the officer said to Renorda Pryor, my attorney at the time, for the federal case, court-appointed lawyer, she asked, did you know he was diabetic? Officer Robert Jones said, no ma'am. He didn't know I was diabetic. He didn't know I had OCD. That's very dangerous. The officer didn't know I was diabetic. And I was in the back of the police car being transported from the hospital to the jail. I could have had a diabetic seizure or coma there. The hospital never checked my diabetic blood sugars. That right there is an error. It is neglect of duty. The police department of Martinsville had committed the crime of neglect and neglect of duty. Medical neglect and neglect of duty. On September 21st, 2018, and I know this for a fact from my own knowledge, I have a printout of the arrest warrant. The warrant of arrest, misdemeanor, local, for indecent exposure. Sergeant R.D. Jobs, Martinsville Police Department, they had arrested me on the time of 5:35 a.m. That was when they arrested me. Now, when did the police take me to the hospital? Let's see. Alright. I didn't get the right record, but it was probably around the late 3 o'clock to the 4 o'clock time. But anyways. Okay, wait. This one says... This one says 4/16. I need to look at all the dates, but here's when I was discharged to the jail police. 4:52 a.m. and the police were there. Robert Jones was there, and he had accused me of lying, and then I looked at him straight in the eyes and I told him I am not lying. And I said I am not lying. I looked at him right straight in the eyes, and you know, so he was there at the hospital. I know he was. I saw him there. He was the one that spoke to me. And then he spoke to me at the area where the jail was, Martinsville City Jail, where they were booking me. And then he accused me of lying again. And then I said, I have autism. You know, people could give misleading statements according to Dennis DeBolt. And he said, how do I even know you have autism? He didn't even know I had autism. In fact, later on, Roberta Hill said that the police had spoke to her, Martinsville Police, about the indecent exposure, and she was asked if Brian Hill had autism. They didn't even know I had autism, and they said I was psychologically and medically cleared. That is perjury. Now, what am I trying to prove here in this video as to the date of my arrest and being discharged from the hospital? What this proves is that the police arrested me within a few hours. The police did not have the time to conduct a thorough investigation. Once the police charge somebody with a crime, they no longer have jurisdiction to investigate it. Yes, and yes, that is true, because that is what happened with me. And the lawyer said they don't have to investigate anything. Once they charge me and it goes to the Commonwealth Attorney, then it is up to the lawyers. This proves that the police department could not have found the guy in the hoodie. Come on, even with murder cases, they're given 24 to 48 hours to look for the murderer. They're given a total of 1 to 2 days, like you see on these crime shows. Like, you know, like you see on crime shows, cops have to do this very quickly, look for the murderer, you know, for when it's a hot murder case. They didn't even give me 24 hours. They gave me 2 hours or less to investigate while I was out there naked, to try to find the guy in the hoodie, according to my testimony. They didn't look for the guy in the hoodie. I don't think they did. And why did they not look for the guy in the hoodie? Because they thought I was lying. So if they're not even going to look for the guy in the hoodie, how can they verify what I'm saying is true or not? They did not investigate. And this is the proof I present to the court. Sealed envelope. Evidence mailed to G. E. Cassidy, Martinsville Police Chief. And guess who it ended up in the hands of? My lawyer, Matthew Scott Thomas Clark. He had this envelope and he did not tell me about it. The only reason why I knew about this envelope was I asked for my case files. because I wanted the lawyer out of my case. I wanted to prosecute this pro se as a defendant. And so, to prosecute the fact that I was wrongfully convicted of indecent exposure. And so, when I got the case files, I found out that this envelope was never opened. Not even my lawyer opened it. And it's restricted delivery. It is still sealed. And I agree that if the U.S. Attorney or Glenn Andrew Hall would like to have this examined in their official capacity, I do not want them sending police to cover anything up, because this video is made to prevent that. You're not going to cover anything up, Glenn Andrew Hall, or you will be exposed to the American people as a crime committer. No one's going to cover this up. Not Martinsville Police Department and not Glenn Andrew Hall. So what have I proven? My grandparents have mailed G.E. Cassidy. That's right. They have mailed G.E. Cassidy. Right here, where it says G.E. Cassidy. And then, second mailing. Even more mailings were given to G.E. Cassidy. It was turned over to the Commonwealth Attorney. And then the Commonwealth Attorney turned it over to my lawyer. The Commonwealth Attorney, Glenn Andrew Hall, did not investigate the envelope. He did not open the envelope. He did not review over the contents of the envelope. If he had done that, the police department would have reconsidered charging me with indecent exposure if they investigated out all of it. And there were witnesses that were in the envelope. I had witnesses that I wanted the police to investigate, and one of them was Pete Compton, the chimney expert of Ace Chimney. He's a chimney service person. He was the one that saw the metal tin on top of my chimney, and that is when he said, I better do something about this now. And, according to what my family told me, he had to take action because of, that. Now, this is not my own words, because I'm just, that would be the, that part would be, considered hearsay. So you would have to ask him for yourself, the witness, Pete Compton. Pete Compton, the chimney expert, he found out that my apartment and my mom's apartment at 310 Forest Street were both exposed to carbon monoxide. And after I was arrested for indecent exposure, my mother was exposed, still exposed to carbon monoxide poisoning. Every time she used the heater in the winter, which is radiator heat, every time she took warm showers, she was being exposed to carbon monoxide because of the exhaust of the gas. So before I was arrested for indecent exposure, I was exposed to carbon monoxide poisoning, carbon monoxide gas. Now, he can't attest to the poisoning, but he can attest to the gas. Now, of course, carbon monoxide poisoning is going to happen when you're exposed to gas. If a bear craps in the woods, it's from a bear. You might see the crap for the bear, but it's still a bear. I'm just giving an example here. Evidence forensic-wise, that if you're exposed to carbon monoxide, you're going to be exposed to carbon monoxide poisoning. Now, this proves it right there. They refused to investigate it. And because the laboratory results were never done and the blood vials were destroyed, it is spoliation of evidence. Martinsville Police Department allowed destruction of the blood vials. They also destroyed the body camera footage that they had recorded on September 21st, 2018. They had destroyed the body cam footage. That is spoliation of evidence in violation of 3 court orders. It doesn't matter that I had a lawyer and they said they have the right to ignore me because I have a lawyer. That doesn't mean that they could have destroyed the body cam footage. They were court ordered to give me the body cam footage. They did not give me the body cam footage. They never gave my attorney the body cam footage. They destroyed the body cam footage. They violated my rights under Brady versus Maryland. I was wrongfully convicted in the General District Court on September 21st, 2018 because they had violated my rights under Brady versus Maryland. They destroyed evidence in violation of Brady versus Maryland, my rights. They have violated my constitutional rights under the color of law. Glenn Andrew Hall openly and knowingly violated court orders in accordance with the discovery rules and Brady versus Maryland. The Martinsville Police Department has violated my rights by spoliation of evidence under Brady versus Maryland. I am entitled to either a new trial or vacatur of my conviction in the General District Court, the Martinsville Circuit Court, and my conviction in the federal court under the supervised release violation. That is all I have to present to the court with this testimony, that I have the evidence that the Martinsville Police Department has committed the offense of neglect of duty. They have neglected their duty. They did not do their job. It is the job of a police officer to investigate evidence mailed to its police department. The envelope is sealed, proving that the police department of Martinsville had refused to look at the evidence mailed to them by my grandparents, by me. They refused to interview the witness, expert witness, Pete Compton. They refused to ask the fire marshals to look into the fireplace. And at the end of this video, I will show you the fireplace. I will show you what the police refused to investigate. I have proven to the courts with this video, I, Brian David Hill, have proven under penalty of perjury in this video, in my testimony, I have proven that the Martinsville Police Department quickly charged me with indecent exposure. They refused to investigate while I was out there. They failed or refused. They neglected their duty. Neglect of duty. The police department has refused to investigate anything. They would not look into the envelope. They would not look into anything my grandparents mailed them. And my mom heard that one of my old friends had tried to email evidence to the Martinsville Police Department. Then they received a notification back from emails saying that you have been blocked from emailing the city of Martinsville. So Martinsville Police Department isn't just returning envelopes full of evidence regarding the indecent exposure, regarding the fact that I'm innocent of indecent exposure. Martinsville Police Department refused to accept evidence, and they're blocking anybody from emailing evidence to the Martinsville Police Department. So the police department is corrupt. Martinsville Police Department is corrupt. And I have proven Martinsville Police Department is corrupt. They have committed crimes of neglect of duty. They have refused to do their job. And they say I'm guilty of indecent exposure when they wouldn't even investigate while I was out there. I like to present to this court that the charge of indecent exposure is erroneous. I am not guilty. I'm actually innocent of indecent exposure. And I agree and promise the court that the other parties can forensically test the envelope for authenticity and validity. I agree voluntarily that if they want the court to order examination of my envelope as evidence, I agree to turn it over to the forensic investigators to look at, to determine that the envelope was in fact sealed. It had never been opened. This is the evidence I present to the court on January 5th, 2022. My name is Brian David Hill. I declare under penalty of perjury that the foregoing is true and correct. Brian D. Hill, signed. Thank you, and God bless you. Justice for uswgo.wordpress.com. Thank you. This is Brian David Hill recording this video to demonstrate to the court on January 5th, 2022 regarding the fireplace. Now, Roberta Hill, the mother of Brian Hill, has cleaned up the fireplace, but there's still evidence of the residue. She wasn't able to completely clean it out. You see the residue, the white residue, even though she has tried to clean it, there's still evidence of white residue, and that is evidence of carbon monoxide gas was flowing into the apartment of 310 Forest Street, apartment 2. And as you see down here, the gas logs have been rusted. So my mom cannot turn on the gas logs. I cannot turn on the gas logs because of the moisture caused by the carbon monoxide gas, that they have been rusted. Now, I also agree that the court can have a forensic expert come into the house and examine the gas logs to see the rust on it and to examine the fireplace for any remaining residue that has not been cleaned out by Roberta Hill. I mean, because, you know, it's been years since the indecent exposure charge, so of course she's going to clean it. Nobody cares. But this proves that Martinsville Police Department did not even go into the house when they were invited. My family was going to try to get the Martinsville Police Department to go into my house, my home, my apartment, and look at the carbon monoxide residue to prove to the police that I was under carbon monoxide gas, which causes carbon monoxide poisoning. And that would have explained to them why I was out there naked on the Dick and Willie Trail on September 21st, 20. They did not look into this. They didn't investigate it. And so this concludes the video and my evidence proving that Martinsville Police Department did not investigate any of this. They didn't look into anything. They just charged me and let it go to the lawyers, let it go to the judges and the courts. They didn't want to investigate Jack Diddley squat. This is Brian David Hill, and I declare under penalty of perjury that the foregoing is true and correct, executed on January 5th, 2022. God bless you.